Good afternoon, everyone. Good morning if you're not in Eastern time. Good afternoon as well in Mountain time, and people in BC. Happy to have you here, and thank you all for attending this webinar. We know that the subject of the webinar today, legal considerations and practical tips for the remote workplace, is extremely interesting to many employers in Canada. We've already had many of you who reached out proactively to actually book a session for a meeting ahead of time as well to plan for after the session. We're also going to be reaching out to all of you as well to make sure that you're all benefiting from additional services and support when it comes to all those things as well. And we'll provide you with a free consultation to go over everything that we review today. Now, as part of our some quick housekeeping for all of you, good to know is that we actually do have the chat and the Q&A available. So preferably if you can actually use the Q&A at the bottom of your screen, which you can see with kind of the two talking bubbles at the bottom right there, very close to share screen, record, and then Q&A. That is the preferred method if you actually have any questions. So please use this. And then we're actually going to get your questions at the end of the webinar. We have a lot of things to share with you, and it's going to be extremely useful and interesting. So at the end of this, we're going to plan about 30 minutes for questions. We may not get to all of your questions, but we will provide you with answers and support at the end if we don't get to your own question. So please feel free, share them. We'll get to them. Now, for our session today, we actually have a few disclaimers. Of course, this would not be a legal meeting without a few disclaimers. So first, today's presentation is not intended to be legal advice. You should always consult with a lawyer before taking action around any of those topics. This is, of course, a high-level overview. So for specific advice, please get in touch. We'll be happy to help. When employing a worker who is out of your jurisdiction, the best practice is to consult with a qualified lawyer in the jurisdiction where your worker is located. So quick introductions for the different speakers that we'll have today. So first, Anatoly Dvorkin. So very happy to have him with us today. Small business owner, legal entrepreneur, founder of 2 law firms, been practicing law for over 18 years and practicing employment law for over 10 years. So you have his contact information here as well. Anatoly will be the one speaking right after me. And then we have Lubisa Durlovska as well, who is joining us also with HRC Law, practicing employment law for over 10 years, from anything from hiring to letting people go or firing as well. Terminations can be tricky. She has all the right advice. Human rights issues, investigations, advising on employment issues, buy-sell agreements as well, and other corporate transactions. Lubisa is the person you want to talk to. And then we also have Errol Tenenbaum, who is also joining us today. He is a partner at Robbins Appleby in the Tax and Wills and Estates Group. 18 years of practicing law. He can actually act as a trusted advisor to a wide range of clients, multi-generational family-owned and closely held businesses, emerging entrepreneurs, individual professionals. So basically, whatever your situation is, Errol can help. Many years of experience in all areas of tax law, including Canadian and cross-border planning, shareholder and partnership agreements, tax dispute resolution, and commodity tax issues. And you have his contact information at the bottom as well. Now, the agenda for today.
Sorry, Mark, if you don't mind, I'll take over here. And thank you so much for introducing everyone and in introducing the presentation. Really appreciate that. And you'll hear from Mark again at the end of the webinar. So first of all, I want to thank everyone for joining us. We had, I think, somewhere around 380 people who registered for this. So this is a very popular topic. I can see that right now we have 193 people who have logged on, which is a phenomenal number of people to be speaking with. So I don't think I've ever spoken with this many people all at the same time. So it's making me a little bit nervous, but hopefully we give you a lot of helpful information, and we hope you walk away with a lot of practical tips and considerations that you can use going forward. So before we even get into the agenda, I just wanted to mention that obviously, because of the COVID-19 pandemic, the remote or hybrid workplace really took off. And although some workplaces have returned to on-site employment, many have opted to remain mostly remote or are using a hybrid situation. And we know a lot of the reasons why employers want to do that. First of all, it could be a lot less expensive for employers. You don't need as much physical space. So when employees are home, you don't have to provide all that really expensive office space for them. Employee recruitment and retention, that's a huge issue right now for employers. And in order to compete in the marketplace, you might have to offer the option for people to work remotely. A lot of employees, having gotten used to working from home or working from somewhere, don't want to come into the office every day. And it opens up your pool of employees in terms of where you can hire from. So you don't necessarily have to hire someone who's very local to where you're located as a business. Those are some of the reasons why employers want to use a remote or hybrid workplace. And employees, from the employee perspective, well, obviously, you get rid of the commute, which is a huge deal for a lot of people, especially those of us who live in busy cities like Toronto, and driving to work every day can just be a killer. It opens up just the same way as for employers, where they can now hire from a much larger group of employees. For employees, they can look for jobs in a much larger pool of employers. So they don't have to look for employers who are only local to where they are. And of course, the ability to continue working during a public health crisis is, hopefully behind us, but we never know what's going to happen in the future. And now that we all know that it's possible, employers and employees alike, to continue working even when there's something like the COVID-19 pandemic going on, I don't think that the remote and the hybrid workplace is going anywhere. I think it's, here to stay. It's not a fad. And that being said, there's all of these benefits to using this type of workplace situation. But because we're lawyers, we're not really going to be concentrating so much on the benefits. What we're going to be talking to you about really are some of the challenges and things that you have to think about in order to employ such a workplace in a way that keeps you safe and minimizes your liability. So with that introduction to the topic, I'd like to get into the agenda for today. So Lubisa is going to be talking about employment standards legislation and how it might apply to the remote worker, health and safety legislation, workers' compensation, and how all of that applies to the remote worker, whether they're in your jurisdiction or outside of your jurisdiction. I'm going to be talking about how employees and independent contractors and dependent contractors differ from one another and how that impacts the remote workplace, and also some specifics that you want to think about when you're looking at your employment contracts when dealing with remote workers and out of jurisdiction workers. And then I'll be going into unintended legal consequences of employing remote workers within your home jurisdiction and outside of your home jurisdiction. Then Errol is going to be talking about taxation and how tricky that can be when you're dealing with out of jurisdiction workers. And finally, we'll end off, assuming we still have time, with practical considerations and tips for all of you to think about. And with that, I will turn the floor over to Lubisa.
Thank you, Anatoly. Welcome, everybody. Nice to see everybody here this afternoon. So I'll start off just by saying we as lawyers, employment lawyers, we speak to a lot of people in the course of our day. We have foreign companies who employ Canadian workers. We have Canadian companies employing remote workers, either in other Canadian jurisdictions or in foreign jurisdictions. And a lot of the time, what we find with our clients is that especially with small and medium-sized businesses, is that employers are generally misinformed about their duties to their employees. And we wanted to tackle that misinformation, and we wanted to talk about sort of what laws do apply to employees out of jurisdiction. So as Anatoly mentioned, there are sort of minimum employment standards in each jurisdiction that will apply to employees, but it's not just employment standards legislation. We're talking about human rights legislation. We're talking about occupational health and safety. So this is just one sort of part of it. And on this slide here, I just wanted to draw your attention to how sort of different the legislation can be from jurisdiction to jurisdiction in Canada. One of the sort of bigger ones is overtime for remote workers. For example, in BC, overtime starts at 40 hours a week. In Ontario, it starts at 44 hours a week. In Nova Scotia and PEI, it starts at 48 hours a week. So you can see if you have an employee in let's say a Nova Scotia or a BC jurisdiction, their overtime will start differently. So if you're paying according to the wrong jurisdiction, you're going to have problems, right? So other differences that I've listed here, and these are just some, this is just skimming the surface, is paid and unpaid leaves of absence, excess hours of work, policy requirements, such as in Ontario, we have policies or mandatory policies, I should say, for disconnecting from work and electronic monitoring that applies to employers of certain sizes. There's termination entitlements that differ based on which jurisdiction your employee is in. There's exemptions from the Employment Standards Act and from some of these specific sections like overtime and excess hours, but those exemptions are different by jurisdiction. And then there's minimum wage, and the list goes on and on. These are just some of the sort of more important parts. So that's all fine and dandy, but which jurisdiction applies to your employee and how do you figure that out? That's kind of the biggest issue that we come across with our clients. And as you can see, in most provinces, the employment standards legislation is mainly silent on who it applies to and who it doesn't apply to. Outside of Ontario and New Brunswick, as you can see, those two provinces have specifications that are a little bit different than the other provinces. Generally, however, the case law has developed when the jurisdiction is being determined for the purposes of employment standards. And up here, and where there is a strong enough connection between the employment and the province, so when the employee lives and works in the province, then that province's legislation will apply. But as we know, there are nuances. Like, you know, when a person splits their time between two provinces, when a person lives in one province, works in another province, then you have sort of different considerations. And at that point, some other considerations that have been taken into account are where the work is done, where the employee lives or where they're normally resident, where the business is located itself, and is the out of province work incidental to, or is it central to the employment relationship? Where does the wage payment occur? And then finally, the last one I have on here, which is kind of a big one, is whether there are contractual provisions that govern which law will apply. But let me get back to that because I just want to look at the New Brunswick ESA first. And in New Brunswick, the Employment Standards Act applies to work carried out for New Brunswick employers, and that's regardless of whether it's performed inside or outside of the province. So when you have somebody, a company in New Brunswick employing someone remotely, it's the New Brunswick Employment Standards Act that will apply. In Ontario, we have legislation that says the employee's work is to be performed, the Employment Standards Act will apply if the employee's work is to be performed in Ontario, or if the employee's work is to be performed in Ontario and outside Ontario, but the work performed outside Ontario is a continuation of the work performed in Ontario. So what does that mean? We have a little bit of guidance in the form of a Ontario Labour Relations Board decision in 2019, Zhang and IBM, where the board found that the Ontario Employment Standards Act did not apply to an employee who worked in Ontario from 2009 until 2015, and whose manager permitted him to work from home in BC from late 2015 until the employee was alleged constructive dismissal in 2018. The employee argued that, yeah, Ontario legislation did apply, and this was because he worked hours which aligned with Ontario's time zone. And he viewed himself as an Ontario employee, and he was working in BC, according to him, only temporarily. But despite these facts, the board wasn't convinced that the work the employee was doing was either being done in Ontario or as a continuation of work in Ontario. Because by the time he had brought this application, he had been working from BC for almost 3 years, and he hadn't set foot in Ontario throughout that entire time. So therefore, at the time of the constructive dismissal, his work wasn't performed in Ontario or a continuation, and the employee was therefore not entitled to any severance under the Ontario Employment Standards Act. Now, I want to get back to the choice of law, because a lot of people think that the choice of law, if you have an employment contract that has the choice of law contained in it, then you can sort of dictate which jurisdiction will apply to you. And that's true to an extent. Again, we have sort of guiding legislation. We have, or not legislation, sorry, case law. In 2018, in McMichael and the New Zealand and Australian Lamb Company, the court was faced with, this is the Supreme Court, the Superior Court of Ontario, was faced with a case where an employee was working in a meat processing facility and also living in California. The employee had signed a contract with the employer that had included the choice of law clause to be Ontario. And the employee brought a claim for wrongful termination in Ontario. I presume that's because California employees don't get as much for wrongful termination as do employees in Ontario, but that's beside the point. And the court in that situation, because the employer strongly contested this, the court said that the governing law can be the law that's intended by the parties, but only so long as that choice is bona fide and legal, and there's no reason for avoiding the choice on the ground of public policy. So on that point, we also have very recent sort of top of mind case law out of the Supreme Court of Canada, which is the highest court in our country. And a lot of you might have heard about the Uber case, where Uber drivers were claiming that they were employees and not contractors, and they took issue with the fact that their contracts, the contracts that they had signed, had them agreeing to the Netherlands being the place that they were going to arbitrate any sort of issues, and that Dutch law would be the choice of law. And in that case, for a myriad of reasons, one of them being the choice of law, the court found that the choice was unconscionable and a significant barrier to access to justice. So in other words, if you have an employee who lives in Ontario and works remotely out of Ontario, and the employer is in Ontario or in a nearby province, and you choose a jurisdiction that is completely not related to the work, to the employee, to the employer, just because that jurisdiction will give the employee sort of less benefits, then that will probably be struck down. You're not going to find a judge that's going to agree with you, and there's going to be public policy reasons for striking that down. So yes, it's useful to have that in a contract, but oftentimes you can't abuse that. So moving on, other legislation that affects remote employees that we need to talk about is occupational health and safety legislation. So occupational health and safety legislation, OHS I'm going to call it, covers things in each jurisdiction like the employer's duties about health and safety, requirements for certain health and safety policies and procedures, like policies for violence, harassment, bullying, requirements for constitution of health and safety committees and health and safety reps, procedures for reporting and investigating incidents, procedures for reporting injuries to employers and to the government. So really anything health and safety related will be here. As you can see on this slide, again, most provinces outside the 3 listed state that the OHS legislation will apply to companies that employ at least 1 person in the province, even if that person works from home, meaning that the employer has to abide by OHS rules in the province where the remote employee works. In Ontario, we have sort of unique wording, and it says the OHS legislation will not apply to workers performing work from a private residence. But I would caution people from not following the OHS in Ontario and beware, because there, the asterisk is there for a reason, and it's because it's not always determinative whether or not the OHS applies. Because a private residence might be different than an employee who maybe uses work share offices. Maybe it's different from an employee who's in a mixed use building, right? There's ways around this. So I would say, even if you're in Ontario, you should really really follow the OHS nonetheless, unless you know you've gotten legal advice and it does not apply to your worker. In BC and New Brunswick, the case is the same. The legislation will apply, but here there are also very specific requirements for policies that need to be provided for those workers who work alone and who work remotely. What's important here that I want to draw your attention to, and why we want to talk about OHS, is that there are heavy fines associated with employers not following OHS laws of the correct jurisdiction. In Ontario, the fines go up to 1.5 million, and then there's jail time for directors and officers who don't comply with the OHSA. In BC, there is the same, and across jurisdictions, it's the same. In BC, there was recently one of the largest penalties levied against an employer. It was $650,000 for failing to consistently enforce policies and ensure safety of workers. So the fines are not small. The liability is large. And then the last thing that I want to talk about is workers' compensation. Canada's workers' compensation system is managed by provincial workers' compensation boards. And each province has sort of different rules around who needs to register, how premiums are calculated, how workers are supported to go back to work. But in essence, the workers' compensation system is intended to provide a wage loss benefit to employees, medical coverage, and then support to help get them back to work. In most Canadian provinces, employers are required to pay into workers' comp in the jurisdiction where the employee lives and works. In New Brunswick, that's a little bit different. They require that 3 or more workers live and work in the province before workers' compensation buy-in is required. I do want to say that there are exemptions for certain employers in certain industries. And the only issue is that the exemptions differ from province to province. So what I always tell my employees, my clients and employers is that you should call the workers' compensation board in the province where your employee resides and see if it is mandatory for you to have workers' comp for them or not. And if it's not, then you might consider private insurance and private solutions, but that's beyond the scope of this presentation. In terms of where accidents happen, because when you have employees who work from home, the question becomes, well, is that a workplace? And what activities are covered by workers' comp and what activities aren't? It's easy enough when a person is on site to say, yes, this accident happened at work, but what about when they're at home? And we have a few sort of guiding cases. One that I think Anatoly will talk to you about a little bit later is the Air Canada and Gentile Paty case in 2021, which is a decision out of Quebec, where the issue around compensation and when the injuries were, whether the injuries arose at work, was sort of explored. In that case, the worker was a customer service agent for Air Canada, and she fell down the stairs at her home after disconnecting from work for an unpaid lunch break. Air Canada argued that the fall didn't occur at work and it had no control over the worker's actions, and when she wasn't at her computer, in other words. And the tribunal sort of started by looking at the purpose of the activity being carried out and its connection to the performance of the work. And it recognized that although workers who work from home are often shifting between personal and professional spheres throughout the day, workers working from home should be protected in the same way that they would be if they were working on their employer's premises. And in this particular case, they found that this employee was at work when the accident happened, and so she was covered by workers' compensation. In Ontario, we have case law from the Workplace Safety Insurance Appeals Tribunal that is indicative of when a person is going to be found to be at work or working. And the key question that they ask in determining when a worker is injured in the course of employment is whether the activities of the worker at the time of the accident were reasonably incidental to the employment, or whether they represented a distinct departure from the scope of employment. So where I think I'll leave it at that. I'm mindful of the time. I have so much more to say, but I will leave it at that. In the next slide here, I just wanted to point out that there is other legislation across the provinces that might apply to your employee. I just wanted to draw your attention: human rights, protection of personal information and privacy acts, accessibility acts, pay equity acts that you should be mindful of, and it should be on your mind when you are employing remote employees. So with that, I will pass it over to Anatoly.
Thank you, Lubisa. That was extremely informative, and and if we had more time, I'm sure that we could continue talking about all those issues for quite a while. But what I want to get into now is this idea of, we've been talking about employees and all the protections that employees have. So a lot of employers would think to themselves, well, an easy way to get around all of this would be to just use people as independent contractors. And the reason for that is kind of demonstrated by this graphic on the screen right now. So there's essentially three categories of workers that exist. There's the independent contractor on the one hand, which gets the least amount of protection from legislation. Then there's the dependent contractor in the middle, which gets the medium amount of protection, and then employees who get the most amount of protection. And so it would seem very simple as an employer to just say, well, we're going to employ workforce remotely, and we're just going to have everyone be an independent contractor. And then we don't have to worry about all of these different things. We'll just simply have them sign independent contractor agreements, and everyone will be happy. And we don't have to worry about any of these protections that employees have. And some workers are very happy to be independent contractors because it helps them with tax write-offs, and it helps them to deduct certain expenses, which they couldn't do as an employee, and there's no withholding taxes, and so on and so forth. So it seems like a happy marriage between worker and employer. But as usual, there are issues with that approach, and I'm just going to talk about the most important issue, which is simply that you have to classify your worker correctly. You can't just decide that someone is an independent contractor and write a contract that calls them an independent contractor and hope that that's going to work for you. There are a set of criteria that different jurisdictions will look at to determine whether someone is truly an independent contractor, and they will look at the heart of the relationship between the employer and the worker. They won't just refer to the contract and give deference to the contract necessarily if the workplace or if the work situation doesn't actually lend itself to being that of an independent contractor. So one of the reasons why, and maybe the fundamental reason why it's so important to classify correctly, is because misclassification can be extremely costly for the employer. And, you want to get this right for a number of reasons, but when the worker is a remote worker, then of course, as I had just mentioned, if you can truly hire someone, or not hire, but use someone as an independent contractor, then you don't have to comply with the employment standards, regulations, the health and safety, and worry about all of these protections that an employee would have. Now, if the worker, though, is out of jurisdiction, you have to be really, really careful. And we're going to talk more about that because in certain jurisdictions, the way that a worker is classified is different than it might be in your home jurisdiction. So, when you start looking at other countries, they have different criteria and they have different legislation that might apply. And so you might think that your worker is in fact an independent contractor, but really in accordance with the law of the foreign jurisdiction where your worker resides, the foreign jurisdiction will consider that worker to be an employee or maybe a dependent contractor. And in some jurisdictions, independent contractors or dependent contractors have employee-like protections anyway. So it really behooves the employer to consult with a lawyer in that jurisdiction in order to make sure you get the classification right, not only at home, but also in the jurisdiction where the worker resides. So here are some of in Ontario and in much of Canada, here are some of the factors that are looked at by the courts, by adjudicators, whether it's a tribunal or even the CRA, anyone who needs to make a decision on the issue of whether you have an employee or an independent contractor, they're going to look at some of these factors. And you can see that there's a lot of factors to look at. So one of the major factors is, who has the control over things like work location, things like work hours and schedule, the territory to be covered, the tasks that the worker is doing, how the worker is going to be performing those tasks. Does the worker have the authority to accept or decline work? Can the worker hire additional people for themselves to help them do the work? Can the worker set their own prices for their services or products? Who's going to be responsible for supervising the worker's activities? Who will deal with customer complaints and decide whether faulty work must be redone? Who's responsible for benefits? Is it the employing company or is it the worker themselves? Who decides on vacation time, when the worker can take vacation, paying vacation, and whether the worker must work on holidays, or does the employer have any control over that, or is it the worker who controls that? So obviously, the more control the worker has, the less they look like an employee and the more they look like an independent contractor. And if you're talking about this issue in generality, essentially the real difference, and it says there's a blurb at the top of the screen that says this, but the real difference between an employee and an independent contractor is that an employee works in the employer's business, while an independent contractor should be in business for themselves. And they really retain much of the control over how much they work, how much they charge, how they work, when they work, where they work. And so the more control they have, the more they look like an independent contractor. Then we're going to look at things like tools and equipment, who owns and pays for the tools that are needed to get the job done. Again, if the worker owns the tools and pays for those tools, they look less like an employee and more like an independent contractor. And here's a big one as well, profit and loss. So can the worker, through their own efforts, increase their profit and loss? So if they control their costs better, can they increase their profit? If they decide to charge more, can they increase their profit? So again, if there's an opportunity for the worker to increase their profit or suffer a loss, then they look more like an independent contractor and less like an employee. And then, of course, there's integration into the employer's operations. So is there an agreement stating that the worker is a contractor? Now, I mentioned earlier that that's not determinative, but it's certainly helpful. So if you do have someone that is truly an independent contractor, you definitely want to have an independent contractor agreement with them. Does the worker are they working through a corporation or a business, or are they just working in their personal capacity? Do they pay taxes for the work they perform, or is the employer remitting taxes on their behalf? All those sorts of things are going to factor into whether or not a worker can truly be classified as an independent contractor. Now, to the extent that a worker can truly be classified as an independent contractor, and they work remotely and they're in your home jurisdiction, then I would say, that is a great solution for an employer to not have to worry about all the things that Lubisa was talking about earlier. But when we're talking about classification of workers, whether or not they're an independent contractor, dependent contractor, or an employee, you have to be aware of applicable statutes. So, for example, in Ontario, the Employment Standards Act says that an employer shall not treat for the purposes of this act a person who is an employee of the employer as if the person were not an employee under this act. So what that's really, it's a mouthful, but what that's really getting at is you can't really pretend. So the legislation is basically saying that, just because you want to hire someone as an independent contractor because it suits your purposes, and maybe it even suits the worker's purposes, but you can't do that. The situation has to be such that when you look at all of those factors that I discussed, the worker falls into the category of an independent contractor. Otherwise, they're going to be an employee. And as I did mention, there is this sort of in-between category of dependent contractor. And what that means is essentially they don't have all the protections of an employee, but they are considered to be reliant on one employer. So you might have someone who basically falls under the category of an independent contractor, but all their business comes from one employer. Then they're most likely going to be considered a dependent contractor. And the way those people might be dealt with is they will get, when terminated, they will be dealt with as if they're an employee, but otherwise they're going to be dealt with as if they're an independent contractor. So in other jurisdictions in Canada, for example, in Quebec and the Yukon, dependent contractors are actually protected by minimum standards legislation, in addition to having that protection upon termination. So my word of advice is really, really do be careful of the applicable statutes. And if you have any doubts, obviously consult with a lawyer about that. So, and as I said, the real risk, of course, of misclassification is that your contractor is going to be deemed an employee. And if that happens, then they're going to be entitled to protections provided by statute. And those protections are going to likely be retroactive to the beginning of the relationship. That means that, let's say you had someone who all along they'd been working with you or for you, however you want to say it, for the last 5 years, and you always considered them to be an independent contractor. Well, something happens and someone looks into it, either because the worker complains or there's some sort of audit, tax audit, for example, and it turns out that the worker is actually an employee. Well, if they're an employee now, that means they were likely an employee from the beginning of the relationship. And that means that you might owe them a whole bunch of money going backwards to the beginning of the relationship. For example, for overtime pay that they may have worked, for vacation pay, holiday pay claims. You might also have a tax liability owed to the CRA because you weren't withholding income tax, you weren't withholding CPP, you weren't withholding EI. And there might be possible penalties and interest owed. And on termination, that worker who you thought was a contractor is now going to be entitled to notice and possibly severance pay, depending on the employer. Now, this gets even trickier when you start looking at workers who are outside of your home jurisdiction, because in foreign jurisdictions, they may not look at it the same way that we look at it here in Canada. So, for example, I have just a few examples here for you. In China, it's uncommon for independent contractors to be engaged directly by an employer. Normally, such a relationship is going to be considered a de facto employment relationship. In France, there is independent contractor relationships are permissible, but there is a risk of reclassification into an employment contract and a finding of concealed work if a relationship of subordination is demonstrated. So in other words, if the worker is really reporting to you and there's a clearly demonstrated relationship where the worker is subordinate to you, then that's going to likely be reclassified and the worker is going to be found to be an employee. And once that happens, then not only might you have problems in your home jurisdiction, but you're probably going to have problems in the jurisdiction where the worker resides. So there's going to be a whole host of liability that arises for you. And, here's another example in the United Arab Emirates. There's only a limited concept of a consultant unless individuals have established their own professional license in business. And this is because most employees have to be sponsored, and that sponsorship is generally obtained by the employer. So those are just a few examples, countries that treat these things differently. Now, even more worrisome is that in some jurisdictions, misclassification not only can result in financial penalties, but it can even result in criminal penalties or steep fines. So in Germany, if you've misclassified a worker intentionally, if that's found to be the case, that's actually a criminal offense. And in Argentina, for example, the severance would be doubled for a misclassified employee. So the bottom line here is whether your worker is within jurisdiction or outside of jurisdiction, you have to make sure you're going to get that classification right. And it's really, really tricky. And in any time you're dealing with a foreign jurisdiction, as I've mentioned in the slide, the best practice is you want to consult with a local lawyer. Sitting here in Ontario or anywhere else in Canada, we're not able to provide you with up-to-date information about the laws in other jurisdictions, and nor are we allowed to. So you really, really, really want to make sure you consult with a qualified lawyer in that local jurisdiction if you have any desire to use a worker in that jurisdiction and classify them as an independent contractor. And also, of course, if you want to have an employee from a foreign jurisdiction, you also ought to consult with a local lawyer, because there's going to be a whole host of employment laws that probably apply that you are not aware of. Now, moving on from that topic and just kind of looking at some contractual considerations when dealing with remote employees. So when you have an employee, typically there's a number of things that are covered in an employment agreement. But when you have a remote employee, there are certain things that become extra important, I would say. So the scope of duties becomes really important. So you want to if you've really nailed down the scope of duties, you can hold the employee to account for the expected performance, and you can clarify the scope of the employee's activity and make sure whether or not it's covered by OHS legislation, as Lubisa was talking about. You want to look at expected availability. So when someone's working from home, obviously, you don't want that employee to be available the entire day, even though they might be available. But you also don't want them not available when you expect them to be working, because maybe they're doing something else at home. So you want to make sure that that's understood by both parties. So you deal with the expected availability of the employee. And here's a big one, and which could help with a lot of the issues that we're talking about today, is you want to agree on the work location. So is the employee restricted to working from a fixed location? So if they're a remote employee, can they only do work from their home? Or, are they allowed to work from anywhere? Can they go to a coffee shop and work? Can they go on vacation and work while they're on vacation, or not on vacation, but take a trip and, instead of taking vacation, maybe just work while they're on their trip? And you want to really nail that down, and you want to make sure that the understanding is very clear. And by doing so, you can decrease the risk of unintentional disclosure of confidential information. You can decide whether or not in advance, whether or not this remote work arrangement is going to be permanent or temporary, and that should be decided. And is it, you want to deal with whether or not it's a hybrid arrangement or an entirely remote arrangement. So as I mentioned at the beginning of the presentation, lots of workplaces are using a hybrid arrangement. Some are completely remote, and that should be understood from the outset. Another important factor is you want to agree on who's providing the necessary tools for the employee to do the work. So the computer and various peripherals for the computer, who's going to be providing internet access, a phone if that's necessary to do the job, office supplies, things like that. And that, to the extent that you can nail these things down in a contract, it really reduces the risk of having a conflict about these things later on. Now, I just want to talk quickly about some of the unintended legal consequences of using remote or out of jurisdiction workers. And so when we're talking about remote workers, there's all sorts of things that people, I think, just don't think about. And it makes sense because it just seems so simple. So someone's just doing their work from home. What could be easier? But as Lubisa mentioned, if an employee injures themselves at home, and they do so during their workday, well, we know that from the Quebec case involving Air Canada and the woman who fell down her stairs during her lunch break, that made the employee eligible for workers' compensation. Now, this was a case in Quebec, and it's not likely to have precedential value throughout Canada, but I do think it'll be persuasive. And quite frankly, I think that a court in Ontario, BC, Alberta would probably find the exact same thing, because that is their workplace. And that was a mandated lunch time by the company. And so they had to go downstairs to get their lunch. They had to leave their home office, go downstairs to get their lunch, and the employee fell. And so it seems really simple, the employees at home, what could possibly happen, but there's an easy example of something that can happen. And then you start getting into things like, well, do you have to provide an ergonomic office environment? And to what extent do you have to do that? So all sorts of things have to be thought about. And we now know, that there are cases where an employee who injures themselves at home may not only, and in this case, it was workers' compensation, but I haven't seen the case yet, but I think there will be cases where, the employer may be sued by the employee for personal injury, let's say, because the employee injured themselves at home during the workday, and maybe they trip and fall over something, and maybe that results in a claim against the employer for some sort of negligence because they didn't do enough to make sure that the workplace was a safe workplace. It seems like a bit of a reach, but I wouldn't be surprised if we see something like that. And here's an interesting one as well, a really sort of weird unintended consequence, I think, that recently came out of the BC courts. So in a case called Bessie and Reach, and I've never heard of a case like this before. This may be the first case like this, but a remote employee was submitting timesheets indicating that she had worked on certain files. Now, in order to track what the employee was doing while working at home, the employer had installed time tracking software on the employee's computer, and that time tracking software showed that the employee was lying. When confronted, the employee admitted to time theft and was dismissed for cause by the employer. Strangely, despite admitting to the time theft, the employee sued the employer for wrongful dismissal and lost. But the employer, not only did they win the case for wrongful dismissal, they also countersued the employee for time theft, and the employer was successful. So the dismissal was upheld, and on top of that, the employee had to repay the employer for hours claimed but not actually worked. But this, it's an interesting case, but this just goes to show that when you have an employee who's working remotely, it's really difficult to know what they're up to during the day. And to the extent that it really matters to the employer, you've got to take steps to somehow make sure that you are aware of what they're up to during the day. Now, on the other end of the spectrum, you're going to have overtime. So I would say that maybe overtime is even more dangerous for the employer potentially than time theft. Because with overtime, what might happen is, and it's so easy to imagine this, is an employee, does their work day, and then they might get an email. They see an email on their phone, so they go back up and they open their computer and do some more work. Then they leave it, and then they do some more work. Essentially, when your home is your office, are you ever really off? And you can accumulate a lot of overtime work without really anyone meaning to. And that could be a really dangerous thing because, if you have an employee who decides that, hey, I should be paid overtime for all of this extra work that I'm doing outside of my regular work hours, and let's say in Ontario over the 44 hours that Lubisa mentioned, well, then that employee is likely going to be entitled to overtime pay, even if you had a clause in the employment contract denying overtime pay unless expressly authorized by the employer, because the case law and the legislation essentially says in Ontario, for example, where the employer knows that the employee is working overtime, or let's say they know and they don't stop it from happening, then they're going to be on the hook for that overtime pay. So I think that's a really, potentially dangerous consequence of having a remote employee if you're not tracking the time carefully. And so you've got to make sure that you have a way of tracking the time, and you've got to make sure that if you don't want to be paying overtime, that you put a stop to the overtime work if and when you notice that it's happening. Now, the other thing, again, like I was talking about before, is when you have remote workers who are out of jurisdiction. So unintended consequences arising from that are that the foreign worker is going to be governed possibly by the employment standards of that foreign jurisdiction. There probably are going to be unintended taxation consequences, and Errol's going to help us with that in just a minute. And again, as I was talking about before, in terms of classifying the worker, there can be really significant liability for misclassifying, and that liability can be more punitive than it is at home. And with that, I'm going to turn it over to Errol to talk to us about taxation issues.
Thank you. I'm just going to start with a real life remote issue. I don't know if you realized I got disconnected in the middle of this, so I have an ongoing appreciation for those who work remotely as I'm sitting in my home, and of course my notes seem to have been lost when I had to reboot. But in any event, I think given the time, I'm going to try to be brief. There's so many, of course. So many different topics that we can talk about. But really what I'm going to focus on is generally from the employee perspective and how it impacts them and the obligations of the employer. And then I'm just going to touch briefly on how it could actually impact the employer directly. And some of these issues are sort of, you've already touched on. The starting point, of course, is it's not always clear where the jurisdiction is that the employee resides. There's a lot of factors that come into play, where their lives are, their families, etc. And there are certain tax treaties, and I'll assume for the purpose of this discussion that whichever country we're talking about has a tax treaty with Canada, but of course that's not always the case. And these treaties are very similar, and they often, while they're not identical, they certainly deal with these issues in similar ways. So, just in the interest of time, I'm going to generally assume for this discussion that we know where the employee is residing, and specifically that they're not residing in Ontario. If we're talking about an Ontario employer with Ontario employees, whether they're remote or not, from a tax point of view, there aren't really any significant issues. Really, what we're talking about is circumstances where either the employee is out of province within Canada or out of the country, residing in another jurisdiction. What everyone should understand, and hopefully you already do, and again, I think Lisa and Anatoly touched on it, is that foreign employees really are taxable on the one hand on their worldwide income, but they're taxed in their home jurisdiction. So on the one hand, if someone is residing outside of Canada, then the Canadian employer doesn't have any. There are no Canadian tax. There's no Canadian tax that would be imposed on that employee by the Canadian government. They're taxed in their home jurisdiction, but of course, what that means, similar to those non-tax issues, the employer is responsible to ensure that they follow the local law. So if you have someone, as an example, residing in the United States, you're going to have to, notwithstanding that they are, working for your Canadian company, you're going to have to ensure that the proper remittance is done in the U.S. and payroll tax, etc. You're going to have those obligations. For somebody who's out of province, again, it's a question of fact. And to be clear, of course, CRA may or may not know about this, and we're talking where it's a clear-cut case. Obviously, if somebody goes home to BC for 2 weeks and it's a working vacation, in all likelihood, it's a non-issue. If we're talking about somebody who moves to BC, then the starting point is you may not know, and you might be remitting their income tax, as an Ontario employee, but they're going to file ultimately as a resident of BC, and so ideally, you really should be remitting as if they're a BC resident. That could be, depending on the province, that's in question. It may be helpful, right? There may be lower taxes, there may be lower payroll tax obligations, but of course there are higher tax jurisdictions. For example, some of the provinces in the Maritimes. So, if nothing else, it certainly adds complexity and added regulatory obligations, and certainly the employer needs to be aware of that, and even more so if it's another jurisdiction, a foreign jurisdiction. Similarly, for those who are, to the extent that there are foreign employers, employers of companies residing outside of Canada, they have full obligations in Canada to remit tax. All the filings that are required for CRA for that employee, regardless of the fact if that employer is wholly based in another jurisdiction, and all of the work that's being done is really with respect to that jurisdiction. Either way, for the individual employee, they're still required to withhold and remit, and again make all required payroll tax payments, etc. So that's really something important to keep in mind. And again, I'm not going to get into situations where it's not clear. But one thing, as I said before, what I wanted to touch on in addition to those obligations is how it could impact you as an employer in terms of your actual the company itself, the organization itself. So what I started off by saying is, so we have a situation where there's a U.S. employee working for a Canadian organization. If that U.S. employee is solely doing work that is that's really Canadian based, whatever the service that they're offering, but they're just doing it remotely from the U.S., then for the most part you have an employee issue. But it's different if they're actually doing work in the U.S. on behalf of the company, right? Even if in that situation, there may be U.S. tax obligations on behalf of the company, right? It could be there's a concept known as a permanent establishment, which really means a workplace. And again, the Canada-U.S. tax treaty sets out what that means, and other treaties do the same. But what that could mean is that employee, theoretically, even if they're working out of their own home, that could be seen as a workplace of your Canadian company, and that could establish you as having a U.S. foothold and having certain U.S. filing obligations of the company, and resulting in potential U.S. tax. So certainly that's something to keep in mind, because again, depending on the nature of your business and what that person is doing, just as importantly, because they have to be able to enter contracts on your behalf and bind you. But it is possible that that could be resulting in you becoming a multinational organization unintentionally, and whether that's the U.S., Mexico, Europe, etc. And that's the same in other Canadian provinces. If someone you have an employee in BC and they're doing business on your behalf in BC, then it could very well be that you have filing requirements in British Columbia that you may have to pay corporate tax, and it's going to be based on percentages of what they're doing and the sales resulting from their work. And that's the case, incidentally, even if they're independent contractors, right? Because even if they're viewed as your agent, even if they're an independent contractor, but they're binding the company, it could still be seen that you're doing business in those jurisdictions. So that's something very important to keep in mind. The last thing I'll touch on, again, being mindful of the time, is which is a fairly extreme example or situation, but if you have executives of the company, if you have the management team working remotely, which again is definitely not unheard of. For example, you have the president of the company works, as a Florida residence and works more than 6 months of the year there. And it's let's say that president is also a director, and maybe there's more than one director in a similar situation. When it comes to the residency of the company, it's theoretically what's called the mind and management, right? In other words, where are the people making the decisions? So in an extreme situation, and again, fortunately, I don't think this will come up frequently, you could have a situation where the corporation is viewed as not being resident of Canada, notwithstanding that it's a Canadian corporation with a bunch of Canadians who are operating the business. If they're spending a majority of their time out of the country, and specifically in another jurisdiction that has a tax treaty with Canada, you could have a situation where CRA would look at it as changing the residency of the corporation, and where that's relevant is in terms of tax rates, in terms of how money can be drawn out of the company by the owners. It could have real world consequences. So again, that's a situation that's fairly extreme, but in a closely held company, in a company that's owned by a family, as an example, and where one family member spends a lot of time out of the country because in warm climates, that's something to keep in mind and obviously be mindful of. Given that we're running a little long, I'm happy to pass it back off to Lubiza and Anatoly and we can get back into any tax issues in the Q&A.
Thanks, Errol. That was really great. A lot of really good things to think about when you have remote employees, but also when you conduct your business in a certain way. So that was great. Thank you. I'm going to keep it short. This is just a little overview about what we've already talked about, but a bit more of on the practical side of things. So in terms of protecting yourself and making sure that you hammer down where jurisdiction is, a solid employment agreement goes a long way. Obviously, a written employment agreement, a handshake is great, but paper is always better. Something that will designate the workplace. These are things that Anatoly touched on. Something that will ensure that the employee can't necessarily relocate without the employer's consent. So you can limit liability in this way. You can also think about your choice of law clause, as was discussed earlier, and also a relocation clause to maybe allow the employer to recall employees or to relocate employees if that's desired or necessary. Obviously, there's a host of other things that could be put in there, but just sort of just to touch on a few things. The other thing is detailed policies are often very important, especially when the worker is sort of disconnected in a way from the workplace and they are working on their own. Having these written policies is really important. Core policies around working from home are going to be important. Health and safety policies are going to be important. I saw a lot of questions about, well, how can the employer ensure a safe workplace? Well, there's a lot of different ways. The employee can do a self-assessment with the proper guidance of their space to figure out if it complies. The employer can do a virtual walkthrough if that's necessary. But again, that should all be in the policies. And policies should also be guided by risk assessment. So if you have remote employees who just work office work, then you want to think about musculoskeletal disorders. You want to think about ergonomics. You want to think about eye strain and the types of things that come with doing office work. And then you want to think about also other policies that will interact with your remote work policy, things like accommodation. What does that look like for remote workers? Emergency plans, as I mentioned, health and safety policies, overtime policies and how you keep track of hours, electronic monitoring, privacy and confidential information and how those are used by employees, and then parameters around that as well. And then consider this I just want to mention that a lot of companies will use employers of record and employer service organizations, which is fantastic because those organizations usually have the tools to figure out which jurisdiction the employee is, and then they can take care of payroll, they can take care of a lot of things, but use with caution. This I should have put an asterisk, and I see I put with caution, right? Because in a lot of Ontario or a lot of Canadian jurisdictions, there is the concept of common employers that can mean that you're still on the hook, even though you've essentially farmed out that work, you might still be on the hook as an employer. So just be careful. And then consider the legal limitations to working from home. And by this, we just meant that that you should think about employees who maybe see clients at home, or employees who use their home space for something other than computer or administrative work, such as storing materials, maybe even hazardous materials, or if they work with machinery or they have to display signage. These things can really change how the work is considered to be done. And there's legal implications, as we discussed earlier. And the last thing is just appropriate information, handling processes. If you have confidential information, if you have IT or IP, intellectual property that is of importance to you and sensitive information, you want to make sure that the flow of that information is done with caution, and that employees have the tools in place to do it properly and securely. And that's where I'm going to leave it, and I'll hand it off to Mark.
Thank you so much, Lubisa, Anatoly, Errol. Fantastic information, extremely informative, I think, for employers today, stuff that they need to know about and be aware of. And now, just before we get to the Q&A, I see we have a lot of questions. We'll get to, if not all of them, most of them. And like I said before, we're going to get to all of your answers and get you answers to your questions as well a bit later. Now, thinking of the remote work and everything else that can apply when it comes to having employees in your organization or health and safety, wouldn't it be great to have someone like Anatoly or Lubisa a phone call away, an email away, without having to track time and make sure that you're calling them only when you really need them? Hey, guess what? That's actually a possibility. At HRC Law, it is actually a service that's available. You can actually have access to Anatoly and Lubisa for unlimited HR legal advice. So whenever you need something, you have a question, you want to be proactive, guess what? You can. You don't only have to go to your lawyer to be reactive. You can actually contact them at any time. You can also receive unlimited contracts of employment or employment agreements when you have to draft them with special clauses, special conditions. Same thing for independent contractor agreements, dependent contractor agreements. They are there for you, and they are putting their expertise at your service to protect your organization. Unfortunately, sometimes things don't go as planned with our employees. We have to terminate them. Terminations can be tricky. It's an extremely slippery slope. Don't do it alone. You actually have, again, Anatoly and Lubisa, who are extremely experienced in those situations, who would be able to guide you through the process and also create your documentation to help make sure you are having everything on your side for that termination and that discussion. And something else that is fantastic is there are absolutely no surprises. We keep everything extremely transparent, from billing to everything that we do with you as well. So it is really changing and transforming the way employment law is available to organizations in Canada. Now, why we're different? You know what? Just I think the fact that you can be proactive versus reactive with your law team is huge. So no hourly fees. Easy appointments. You just have to book something in their calendar link. You have access to it and you can see their schedule and you can book whenever you're available, whenever it works for you. No retainer. That also is something fantastic. Easy follow-ups, and they actually reach out proactively to make sure you're happy and the situation is resolved, which is great. And no hidden fees. So outstanding. Everything is there to be able to have a good relationship as well. And again, be fully protected and have that well-deserved peace of mind that was not accessible before HRC Law was created. Now, for everybody here today as well who joined the webinar, we actually have a special for you. So if ever you do decide to move forward with the unlimited legal advice service from HRC Law, you will actually receive a free month in your program, which is great. Free money is always well received. So we're always happy to get that. And of course, our team is always happy to serve you and provide you with the best possible advice. So as mentioned at the beginning of the presentation, we're actually going to also be reaching out proactively to all of you to offer you a free consultation to go over any additional questions that maybe you've had after the fact to make sure you're well looked after. And now we're also going to be sending an email with the webinar. So figure about 24, sometimes 48 hours before the recording is fully ready to go. And you're going to receive that by email, in addition to a remote work best practice checklist that you will have as well. I've seen a few people also request the independent contractor versus employee checklist. Is that something that we can also add on there as well? Yeah, so we'll add that too. And
yeah, we can provide that, no problem.
Thank you so much, Anatoly, Lubisa. And now we have a few questions. So I've seen Nadine. Nadine has been asking a few good questions as well throughout everything. We'll see her name pop up. So Nadine, I hope you're still here as we actually are going to go through your questions. So first one was health and safety legislations. If most of our workers are now working remotely, do we have to maintain the standard health and safety committee or process?
I can take that one. So it depends on which jurisdiction your employees are in. If they're spread out, then you can. There are many overlapping requirements in terms of occupational health and safety, but a lot of them are different. So you will have to look at the jurisdiction where each employee lives and works, and figure out what is required there. If a committee is required, and what are the requirements for the size of the company, whether a committee is required or a representative. But it really just depends on the jurisdiction.
Thank you, Labisa. And another question was, if an employee is hired based on them living in Ontario, but starts working primarily in another province, do we still follow the Ontario laws?
I'll take that one. Yeah, so that's a good question. If you have an employee who starts working in Ontario, so first of all, I would say, if you want to prevent that from happening, refer back to what we said about having contracts which stipulate that, the employee cannot move without the employer's previous consent. But if in fact the employee has moved and that's sanctioned by the employer, or whether it's not sanctioned by the employer, but the bottom line is they have moved, they're now living in another jurisdiction, that employee is going to be subject to the laws of that jurisdiction. So the employment standards of that jurisdiction are going to likely apply. If you have a contract that may be stipulated the jurisdiction, that might come into play. But I would think that if someone has actually moved their residence and now lives in another jurisdiction, the laws of that jurisdiction are going to apply as opposed to Ontario's.
I would just add to that, that in Ontario, what we're also looking at when someone moves out is the work performed a continuation of the work that was performed in Ontario. So it's really kind of very contextual. And I hate to be that person, but it really depends on the situation, what the person does, how they do it, what is the connection, right? Because we have that case. Also, the Ontario Labour Relations Board case, or sorry, it was the I forget the name. I have to refer back to my notes. But nonetheless, there was that case out of Ontario that said that Ontario law didn't apply where the person had moved out for 3 years, and there was nothing connecting them back to Ontario other than them working in the same time period as Ontario employees, right? So we have to think about all of those things. If you want specifics, though, you can definitely contact us.
Thank you, Anatoly. Thank you, Labisa. And now we have another question from Janice as well, who's basically talking about digital nomads who are Canadian citizens, but they basically travel the world by choice and not to perform their work or because the employer is asking them to. Now, what are the conditions for those people traveling around the world with their laptop?
It's a really tricky one because they're moving from place to place. So, depending on where they are at that specific moment, they might be subject to the laws of that jurisdiction, but it all depends also on how long they're in a particular jurisdiction. So if they're sort of like 2 weeks here, 2 weeks there, they're not likely to become considered residents of that jurisdiction. So the laws of that jurisdiction are unlikely to apply. But if they are there for any, significant period of time, and certainly, in a lot of places you're looking at more than half a year, then they will have they'll look at them as if they've set down roots in their residence, and then the laws of that jurisdiction will likely apply. But it's so hard to say with someone who's moving around so frequently. It does pose a lot of issues for employers potentially, because you never know if you're going to be subject to the laws of that jurisdiction where your employee is currently working from, even though you didn't ask them to go there. They're not there to do their work. They're just, as Janice said, they're just there to, as a digital nomad. They're doing it for pleasure and travel purposes, but yet there might be ramifications for the employer.
Thank you,
And
Anatoly.
I'll just add on the tax side, it's sort of similar to what Anatoly said. I mean, technically, if somebody working there for 2 weeks, if they're doing work in a specific jurisdiction, it's possible that jurisdiction will claim that they owe taxes for that 2-week period. In practice, certainly that would be unlikely, firstly, to ever put any sort of obligation on the employer. And in practice, I think we all know that employee is not going to, for the 2 weeks they spent on a beach, on a beach somewhere in the islands, they're most likely not going to be filing a tax return in that jurisdiction. But at least theoretically, there could be tax consequences. And certainly, as Anatoly mentioned, if we're talking about a longer term stay, especially over that 6 month period, even though from a Canadian tax point of view, they might still be considered Canadian residents, for sure, you could start getting into a time where you're going to have, both for the employer and the employee, tax issues.
Thank you, Errol. I think it's incredible how tricky it can actually get, and the different things we have to think about as employers and employees as well in this remote work environment. Now we have a question about salespeople. So let's say we have salespeople in our company. We're based in Ontario, and the salespeople basically work from home, and they travel with the company vehicle to meet with clients. And sometimes they do go in Quebec or Manitoba or different jurisdictions with their vehicle. What applies then?
Sorry, did we say that they are out of Ontario?
We don't know. Let's say for that particular scenario,
let's say
they do.
So it just changes just a little bit, because like I was saying earlier, work done that is an extension of work done in Ontario still falls within the jurisdiction of Ontario, right? But that's not necessarily the case in other jurisdiction when you have someone working there. And also, if their work location is primarily in that province, but they travel for work, then it'll be where they live that the laws apply from that jurisdiction.
And then for the health and safety portion, if I travel outside province for, let's say a day or two or a week, does that impact also the jurisdiction I'm going to fall under for health and safety purposes?
No, for health and safety purposes, it has to be where the person lives and works, but the travel to and from clients' residences or clients' businesses will extend the workplace. So really the home where the person works, and then the travel to the client, and then at the client, that all extends the workplace. So that's all workplace. So for the purposes of health and safety, yes, it'll be the legislation where the person lives that will apply, because mostly they will be working from there. But when you're thinking broader terms about what you should be covering in terms of health and safety, it should be all of those situations, and there should be policies considering every one of those situations, and workers' compensation as well should be considered for the province where the person mainly works from.
Right. Yeah, thank you. It does make sense. Thank you so much. And Nadine, another question. So if as a company we provide health and dental benefits based on Ontario coverage, are we obligated to provide employees that live outside of Ontario benefits specific to their province of residence? Do we know that?
So I'm not entirely sure what Nadine means by benefits based on Ontario coverage. And I would say also, this is not a legal obligation necessarily to provide, a group health and dental plan. So I would need a little bit of clarification, I think, from Nadine to be able to help her with that one. But I would say that, first of all, it's not an obligation to provide health and dental, insurance coverage. That's a sort of an added benefit that they're choosing to provide. And then with respect to, that it's based on Ontario coverage, I'm not entirely sure if what she means by that is that the insurer is only willing to cover employees in Ontario. Do they also have to find another insurer who's willing to cover employees in other provinces? There may be some workplace issues between employees. If some employees have coverage but others don't, that could result in some workplace issues. But I don't see that so much as a legal issue per se.
Thank you, Anatoly. And Janice had a question as well around basically right now, most of the recipients of remote tutoring or mentoring services, so students and their families, are Ontario residents. Though some of their independent contractors may be residents elsewhere temporarily or permanently, as well as their company is also based in Ontario and they're an Ontario corporation. And now she's wondering if any of the topics that were discussed could actually impact her in terms of determinant, or I can't pronounce that word, but if you see the question from Janice, the last sentence, so could it actually impact the jurisdiction of residence for those independent contractors? I guess that's the question.
So I can chip in there. I would say that it may, because as we discussed, we have to talk about, there's a couple of things to unpack here. First of all, we have to talk about, are they really contractors or are they employees? And if they do end up being employees, then which jurisdiction applies? If they're truly contractors, then you don't have to worry about those minimum standards necessarily, other than occupational health and safety, which applies to sort of all workers. But I would say that the place of residence of those people will make a difference, or the workers will make a difference to which jurisdiction applies. Again, we have to take context into consideration here, and have a little bit more information before we can give a specific answer, but that's my general answer.
Thank you. I think it's great considering what kind of the details that we had. So thank you, Lovisa. Appreciate it. And Kim is asking, health and safety in Ontario. We are working hybrid. What are my obligations for providing ergonomic equipment, desk chairs in people's homes? And they're all office workers, office from home workers.
Right. So that's a really good one. What I would suggest is first figuring out what ergonomic issues might be cropping up. And maybe, like I said, you want to do a there's obviously privacy issues. You're not going to walk into somebody's home to do a walkthrough, a health and safety walkthrough, but you might get their consent to do a virtual walkthrough. Or if that's not possible, then maybe you give them the tools or guidelines with which they can go through their physical space and figure out, based on the guidelines, whether or not they meet certain standards for ergonomics, for eye strain, for this, that, and the other thing, whatever the issues are. And in terms of the need to the employer to provide it, I think around that there's a few different ways to go about it. You can, if you identify it as an issue after doing this sort of walkthrough, then you can discuss with the employee to provide it. If the employee brings that to you and says, I need ergonomic chairs, I need wrist, those wrist things for the keyboard, or some other sort of equipment, then it becomes a question around accommodation and being able to give that person the tools they need to do their job effectively and safely. And in that case, I would suggest that they do need it. But sort of will depend on what the person is working with at home to begin with. Because a lot of people, if they're already working from home, they already have that. Now, that said, a lot of employers will have a work from home setup that they prefer, and ergonomic products that they prefer, and they will give employees a certain amount of money to set up their home offices, and they'll have a choice of certain ergonomic chairs, computers, other equipment that the employee can choose from, so that the employer can ensure that the products being used are ergonomically correct. But again, it depends on the situation.
Thank you, Lovisa. And I think you kind of answered Alex's question as well around, if when I'm employing some people outside of province, would an employer be expected to visit someone's house? So fly in at great expense and then I actually go through everything. So no, there is no such thing, right? So it basically comes down on.
I wouldn't recommend it. No, I don't think it's necessary. Yes, you have to take sort of every reasonable precaution. Is it reasonable to expect that you're going to fly to another province, enter a person's home with or without permission to get that information? No, that's not reasonable. But like I said, there are other options that respect privacy, that are viable and reasonable, that you can do to make sure that you are covered and your employee is safe while at work at home.
Great. Thank you, Lovisa. And next question from Maria. If an employee is given permission to work in another province during the summer, for example, PEI, is the employer, let's say they're located in Ontario, responsible for following those provincial regulations?
So I'll tackle this one, Lovisa. If you have anything to add, feel free. And then I'll also just say, I hate to cut this short while there's still about 102 participants and lots of questions, but we are up at our limit. We're at 3:30, so I'll answer this one with that. Afterwards, we'll have to say goodbye to everyone. And for anyone whose questions we didn't answer, please feel free to reach out to us. You have our contact information, our emails. So please feel free to reach out to us, and hopefully we will be able to assist you that way. To answer Maria's question, I think if the employee is, just going there for the summer, most likely you're going to be okay just following your Ontario, the Ontario laws and regulations. I think it's one of those situations where you have, a temporary work situation, and you're, unlikely, it's unlikely that the other jurisdiction is going to you're going to have to comply with the requirements of the other jurisdiction, just given the very temporary nature of that situation.
Fantastic. Thank you so much, Anatoly. And thank you so much, Errol, Lovisa, for sharing your knowledge and your expertise with everybody today. And thank you all for attending this webinar. We sincerely hope it was really helpful. And of course, if you need more information, the team will reach out as well to provide you with a complimentary consultation. And of course, you have our contact info, so feel free to reach out for anything you might need.